Well, good morning, everyone. Sorry for this brief delay that we had here. Just some technical issues that we always have, that we always face when we have to connect international participants like this. I am experienced with this, so it always happens in lives, but it's a great honor and a great pleasure to be with you, with this distinguished panel, and mostly with this distinguished audience that we always have here at the CMA CIESP FIESP, the Center of Mediation and Arbitration of FIESP here in São Paulo, and promote a dialogue, as we are going to have here this morning, between Brazil and India, is talking about the future and also talking about the present. We've been reading about the development of arbitration in India in the last years and how strong it is becoming there. And also the role that Brazil already plays at an international level when it comes to arbitration and international arbitration. And we are here with the opportunity to we are building a bridge between two of the most important arbitration centers in Brazil and India, and I would also say that of Latin America and Asia, because FIESP is part of the arbitration practice in Brazil since the very beginning, even when there was no arbitration law yet. And the Mumbai Center of International Arbitration is also one of the most important centers of arbitration in Asia and mostly in India. Even because it is in Mumbai. Mumbai is one of the most important cities in Asia, one of the most developed. I've been there, so I can tell you it's a wonderful city and a wonderful place to be and to make business and meet wonderful people, just as Neeti, who is joining us for this event. So I would like to thank a lot Neeti, who's hearing us from India and participating with us for the presence here in our event. I know that India last week had a full agenda of arbitration in the Indian Arbitration Week. We have here now the São Paulo Arbitration Week. We are part of the São Paulo Arbitration Week, this particular event. So it's a great pleasure to have you with us, Neeti. I know how much you've been working those days and traveling around the world. So it's really nice of you being here with us. Also with this, with the time challenges that we have, you are 8 hours ahead from us here. So thanks a lot. And also, I would like to thank FIESP and CIESP for this great opportunity for us to talk about those topics that we are going to address today. And Lilian, you are one of the most innovative persons I know regarding arbitration. You are always on top of questions. You are always on top of the hot topics that we have and new technologies, new everything that is new is coming for us through you and through CIESP and FIESP. It's a great pleasure to be here alongside you. Thank you so much for the venue. It's very nice to be here. And please, my Professor Claudio, not only one of the greatest practitioners of arbitration in Brazil, but in my opinion, the best teacher of international arbitration in Brazil. Professor Claudio is known for the outstanding work he's doing in PUC, in the Pontifical University of São Paulo, regarding arbitration and training students to participate of the VISMOOT and other moots and our arbitration competitions that we have worldwide in Asia, in Europe, here in Brazil. And be with him here today is also a great pleasure. So thank you so much for you to be part of this. And we will discuss some issues here that we have kind of discussed together. I suggested some of them, then we discussed a little bit before starting this event. I don't know if Lilian wants to make some starting remarks.
Oh, thank you, Nantala. It's a pleasure to receive all the people here. It's a pleasure to have the opportunity to talk with Neeti and talk about our experience. So thank you very much, Neeti, for being with us here.
My pleasure, really. No, thank you. I must say, Nantala, that it's really an honor to be here. And I'm very sorry that I'm not joining you in person, given that we had some, like Nantala mentioned, that we had the India ADR week, which unlike other arbitration weeks, we just don't do it in one city. We were traveling around India in 3 different jurisdictions, and we just concluded it Saturday. So it was a bit tough for me to travel, but I'll try my best to be there next year in person. And thank you so much for having me.
Professor Claudio, do you want to make some starting remarks?
I just want to thank you, Favasho, for the invitation, and Lilian on the FIESP. It's always great to be back at the CAN and to share ideas and experiences, and hopefully enlighten the youth and whichever audience we have, not only in person. Thank you very much for being here, but also online. It will be a pleasure.
Well, thank you. Let's start the discussions here. We have some topics that we would like to cover, but the idea is to do it in a lighter way. We can treat this more as a dialogue and a conversation than a panel with formal presentations of the topics. So I think it would be nice if we could start with the Indian perspective, and then we move forward with our perspective here in Brazil, and also the challenges that both institutions are facing regarding those topics, and the solutions also they are presenting. It will be very nice to cover this, because it will, of course, enhance the collaborations between Brazil and Indian arbitration. As I told you earlier, as we are discussing also among us, India is facing a very interesting development in arbitration. So it will be very nice for us also to learn from you what has been happening there. So shall we start with diversity, or we start with a more broad? No, diversity. Okay. The first the first topic is diversity in arbitration, and what the Mumbai Center of International Arbitration is doing in this regard. And we then hear something about Lilian and make comments. Please, Claudio, feel free also to make your comments on those topics. Please, Neeti, what can you share with us regarding diversity in arbitration in India?
Thank you, Nantala. I really like the beginning of the topic with diversity, and also to have an equal representation on the panel as well, with Lilian and me being there. So I think that's a good beginning for the diversity itself. at least. For the ones who are not aware about the Indian arbitration scene, let me just give you a bit of a background and then to go into what efforts are being made in India and specifically with MCIA. So in India, arbitration generally, as we appoint arbitrators, it's the retired judges whom we see as arbitrators. And that is also a reason that in India, for the longest time, that arbitration has taken a bad name. When I talk about arbitration as well, I talk about ad hoc arbitration. That's how in India we still do most of the arbitrations, almost about 70%, sometimes to 80% arbitrations still being done in the ad hoc manner, which is to say that no institution is really involved. The reason for the setting up of the MCIA, we are now about 7 years old, was this because India didn't really have any Indian homegrown arbitral institution. And we saw a lot that the Indian parties would be going to either Singapore or London or Paris to resolve their disputes. So that was the genesis. Clearly, of course, we are now seeing an uptake of institutional arbitration in India. There is a push from the judiciary, from the business houses, from the lawyers as well, that people need to start moving from ad hoc to institution. But it's a gradual change. It's not something that we're seeing overnight, things are going to change. But because we had ad hoc arbitration and because we had retired judges who were acting as arbitrator, we literally saw that whatever was happening in the courts was being replicated in an arbitration proceeding as well. You would still apply the Civil Procedure Code, which is an Indian procedure code applied in courts. There were delays and all the associated problems with the litigation and the court structure. With the institutional arbitration picking up, and I think generally the knowledge increasing as well, there have been legislative amendments as well. We've had a couple of amendments in 2015, then 2019, and then 2020 as well. We are now seeing that the practitioners have started to accept arbitration appointments. And because of that, we as an institution have been able to appoint a larger number of people than the regular retired judges as arbitrator. Just to give you a figure, last year, MCIA had 33% of its appointment as women. This year, we are already seeing that we have almost about 50% of our appointments are women. And we still, of course, have a few more couple of cases I'm hoping to get in this year. And we may be able to give you a number at the end of the year, which is better than 50% as well. Having said that, it's not really easy in India to build up on that diversity as well, because it's a systemic change. If you look at the practitioners in the law firm, the ratios are very skewed against, I would say, women lawyers practicing either in the court or in the dispute resolution or being in the senior position in the law firms as well. So to find the right balance of being able to appoint, women arbitrators as well is not an easy job. Of course, I'm only talking about one aspect of diversity, which is the gender diversity. There are other aspects of it as well, but I think India still is going to take some more time where we can start having more dialogue on other sorts of diversity. Right now, our concentration more is on gender diversity.
Very interesting, even to learn how ad hoc arbitrations have been playing the most of the part in India. Here in Brazil, the story is a little bit on the other way around. We have much more institutional arbitrations going on. So Lilian, what is the picture here in the CMA about diversity, please?
So I'm sorry, I'm a little voiceless, but I will try. Here we understand that the scenario is good for female arbitrators because there is a perception that men are genuinely thinking about to appoint female presidents for the panels. So here in CIESP, FIESP, we perceived that the percentage of male arbitrators in the position of president on tribunals, it's good, more than 55% in the last years. So it's a good scenario, I think. But when parties need to indicate, it's a little bit different. The preference until now, it's men's, in fact. But when we have a chance to appoint as institution, we do a study and always consider female arbitrators for the positions, but it's necessary to think about the matter if we need some expertise for the case. So the gender, it's a factor, but it's not the only one.
Yes, it's true. We need arbitrators. We need diversity in arbitration, but we need also diversity in competence. And we have here in Brazil, men and women very competent in many areas, and mostly in all areas. But we know also that sometimes people are busy, have no agenda to participate on arbitrations, are already committed to our professional engagements. So normally this challenge goes on and moves further only, even when you take the initiative to promote diversity. Claudio, what is your view on those topics?
Well, first of all, I have to agree with everyone, even with your comment that we're moving. I mean, we don't do ad hoc arbitration for some reason. I simply can't gather the reason for the absolute lack of ad hoc arbitration. I understand the preference for institutional arbitration. It's my own preference, but the main point in terms of diversity is what you all just said. I mean, Lilian just mentioned. I mean, it takes some time. I've been doing that, sitting on tribunals for the last 20 years or so, from the outset of arbitration in Brazil, and I'm actually feeling that difference, gender-based, mostly gender-based. And I also have to agree that it has to be a meritocratic system. It's probably the most important issue. And just like Nantala said, it's really easy nowadays in terms of gender to have a mixed tribunal. I myself, I'm trying to appoint as many women as possible, competent ones, of course, and there are a myriad of colleagues really able to do anything a man can do. But it takes time. It takes time. I mean, I have lots of gray hair. Well, actually, I only have gray hair, but some of my older colleagues, they try to be a bit more resistant to the idea, and that's their culture. And that's what parties look after. I mean, if they're looking for a arbitrator, which is traditional, and depending on the nature of the case, they will probably go to a older arbitrator with more experience and with that cultural background. I mean, it's all about cultural background. It doesn't have to be international. It could be domestic. So in my view, when we have an entirely male or female panel, it's on purpose. I mean, that's what the parties are looking for nowadays. I mean, if we were talking about not long ago, 10 years ago, I would probably say otherwise. But nowadays, I think we've reached the equalization point in terms of gender diversity. I think at this point we should move towards diversity in terms of ethnicity and even physical disabilities or other genders, which I'm not familiar with, but it is important. It is important. I have to agree.
There are many researches that have been released in the last years talking about diversity and how diversity improves the quality, even the quality of arbitration decisions, because it brings more perspectives of the issues when you have a more diverse set of people working on it. We are not stick to the European or American view also. So we are here promoting a collaboration between Brazil and India. This is already a diversity when we think about international arbitration as a whole and the developments of international arbitration, at least in the classic period, when we had only Europe and United States doing everything around. Now we have arbitration moods and competitions all over the world, and big and very important ones. We have very important centers of arbitration also in many other countries. I am studying BRICS for a long time, so Brazil, Russia, India, China, South Africa, they all have important arbitration institutions and arbitration practitioners. So we are with this very event already promoting diversity, as we are promoting a dialogue between Brazil and India, two very important arbitration jurisdictions, arbitration-friendly jurisdictions. We have some developments in India that Neeti told us when we were preparing this event that are very interesting, and we would like to address them in a while. But prior to that, how in India, the Mumbai Center of International Arbitration and the arbitration practice as a whole, Neeti, is dealing with the young practitioners and the youngest practitioners, even as lawyers, but as arbitrators as well. How you are encouraging people to seek this career and to develop themselves. What you see as the state of art of this particular point in India?
Thanks, Nantala. No, like I said, let me just divide this into two parts of it, right? One is that what are the young arbitration practitioners, the young practitioners, how we are making them a part of it, and what role really institutions, courts, or MCI is really playing in that. As many of you may be aware of it, that in India, we do not have an arbitration bar. People who practice in the courts are the ones who practice arbitration as well. And because, like I said, you had this whole problem of a court system replicated in arbitration, what we started to see was that usually, typically, your arbitrations, for lack of a better word, were like stepsister to court litigation. So you would have them starting at 5 p.m. in the evening after the courts, close, go till up to 8 p.m., 9 p.m. You would do them on Saturdays, sometimes on Sundays as well. And that's not a healthy way of how you would want to, set up the ADR practice or arbitration practice in a country. But what we are seeing now definitely is that the younger lawyers, and when I say younger, it's in the age bracket of about up to 50. In arbitration, we define young also very differently, right? So in arbitration, I say that we have this lawyers in the age bracket of about 35 to 50, if I may call them. And they are the ones who are now progressively doing more arbitration work. So they would encourage to have arbitration hearings done during the day, not in the evenings. They would not want it to have on Sundays. So there is a growing arbitration bar in India with the younger practitioners. In India, we have more than 30 high courts. Our high courts have both appellate and original jurisdiction, so which basically means that they appoint arbitrators. When the parties are not able to agree on an appointment of an arbitrator, you usually go to a court, ask the court to appoint an arbitrator. In India, some of our courts, I wouldn't say all, but some of our courts are now progressively appointing younger arbitration practitioners, again in the age bracket of about, let's say, early 40s, late 30s, going up to mid 40s and late 40s as well. We consider them young because, like I said, we usually have retired judges. So in comparison to that, this is very young. And then with MCIA, like any other arbitral institution, I say, we have something we call as the young MCIA, which is for the lawyers aged 40 and below. I don't qualify in it anymore, unfortunately. But they're a very vibrant group. They conduct the events separately. They have their own networking events, promoting each other, where they can get the appointments done for smaller, value matters and all as well. And we already have about 10,000 members of the Young MCIA, which is, of course, like I said, a growing number. Just last week, when we did the India ADR week, we had events which were happening all around the YMCIA. So they had discussions, getting people in, in that age bracket to come and discuss about the best practices. So I think fairly we can say that the younger practitioners' acceptability, not only as a counsel, but as an arbitrator in India, is on the increase. Also, I know that we have on conflict of interest and IBA a topic to be discussed later, and I will come on to that and mix the two. But because India probably is the only jurisdiction which has adopted the IBA guidelines in our act, so we need a larger pool of arbitrators as well, because you cannot appoint the same arbitrators. I think that's where the younger practitioners have played a very major role. So it looks like a good time to be in India if you're a younger practitioner.
This is very nice. We can see that here in Brazil we have initiatives like this as well, promoting arbitration for younger practitioners. Mostly people here. We have one of the top, one of the youngest, but one of the top promoters of arbitration for students and young practitioners. Claudio has a huge experience on that. But Lilian, what CMA, CIESP, FIESP is doing on this regard in promoting international or arbitration as a whole for young practitioners?
Thank you. Well, about the diversity, when we receive some case with small claims, and we are asked for appoint the arbitrators, we usually think in younger arbitrators. It's an opportunity to give this opportunity for a younger arbitrator. But we have some special programs here. Last year we started a program with high school, with Porto Seguro College, and we promoted some meetings about mediation with the students, and it was very interesting because they don't know nothing about it, and the students are thinking about the future. So when they practice the mediation, it's an opportunity to think in another possibilities in the advocacy, not only about courts. So it's a very interesting program, and we will expand this program to the Sistema S. It's a program from the industry here in Brazil that supports many colleges. So we will promote this kind of program to the Sistema S to here. And we usually receive here too some simulated hearings for students for graduation. So as the arbitrations are confidential, so they don't know what how the hear works. So it's a great opportunity to practice and to see this room and understand how the players here talk, and it's a great opportunity for the students think about the future and see that there are a lot of opportunities in advocacy. So there is our initiatives.
Very nice. We can say that CIESP and FIESP are not only promoting arbitration for young practitioners, but for very young practitioners, people from high schools or colleges, and promoting the youth. So it's very important, because when we are there in high school, when we were, it was a long time ago for me, but when I was in high school, if I had the opportunity to know a place like this, and to know that lawyers are not only the ones who go to courts or who stays there in law firms drafting papers, maybe it would also encourage me as a future practitioner. I only had access to arbitration, mediation, and all those topics when I was already in law school. So it's a good way to encourage new practitioners. And Claudio, you are the great authority on this topic, so please tell me something about it. I know we don't have time for you to talk about everything, but
just a quick perception. I mean, I've been working with the young students for in the FIESP particularly for the last 17 years. So it's been a whole generation of practitioners. Nowadays, it's really hard to enter into a hearing room or to have a high-level debate in arbitration without former FIESP participants. Being young is a fact of life. I mean, we've all been there. So my main challenge is to make them believe that they're ignorant. In the acception of the word, to ignore something is not to be aware of it. It's not a curse. It's another fact of life. I mean, as they gather experience, they will deliver a more experienced outcome. But on the other hand, it's not a disadvantage, because young people, they're very open to everything, not only technology. I mean, mostly technology, because technology nowadays gives you an outreach that we've never had anything quite like that before. But they're open to ideas, they're open to concepts, they're open to protocols that once we get to know, we get to like it, and it's the task of the older generation to craft it, to shape it, and to deliver. I mean, in terms of marketing, it's what we have to deliver to our consumer base, which are the law offices, companies, arbitration institutions, and to the public at large. Once you've reached, and of course we're talking about commercial arbitration, but we're talking about commerce, and commerce, as far as I understand, is the greatest distributioner of wealth and knowledge and everything. So it's possibly the most important task that we have, is to shape the young generation and to prepare them for taking over our position, which is also another fact of life.
Well, this is why many students come for you. This particular view and the way Professor Claudio deals with it is very inspiring for many people. How many generations of students have been with you? I don't know. Napoleon was the first or not?
He's amongst the first.
I'm not talking about Napoleon Bonaparte. He's another.
Thank God.
Yes.
Now, right now, I have former students in high level positions all over Brazil, but also in the UK, in the United States, and in France. Not in India. Maybe next time. Who knows?
Yes, I was talking about Napoleão Casado Filho. He's the president, he's the chairman of CIESP Brazil branch, and one of the top practitioners in international arbitration in Brazil. And he's not only a former student or a forever student of Professor Claudio.
If I may, if we have that entry into the Vismut, it's because of Napoleon, because I've given up. At some point, I said, well, I mean, the students, they don't want to develop that skill. They really don't want. And Napoleon, he came to me and said, no, they do. They're not aware of their need. And he was the one who made it possible.
Yes, and he's been doing this in Paraíba as well, in very in places that here in Brazil we don't have a lot of tradition when it comes to not only to the arbitration but international law and all those topics that we have here in Brazil, Rio de Janeiro, Belo Horizonte, Porto Alegre. Napoleon is also responsible to spread the word. So it's very nice, and it was all rooted here. So let's move on here. Professor Casella is there? No. We have a surprise. Professor Casella will jump in some minutes. He's been giving classes in São Paulo University, so this is why he couldn't be here with us in this room. But he will give us in some minutes just some brief remarks, as he's making an effort to join us and say some words about BRICS. He's the greatest authority in Brazil when it comes to law and BRICS countries. So in some minutes he may jump around here. Let's move on. And I think, how are we with time? Okay, no. Let's talk about a little bit more harsh subject now, which is conflict of interest in arbitration. Here in Brazil, we have been facing some challenges on those topics. Some arbitration awards have been set aside by our courts because of the levels of conflict of interest that we are setting up here in Brazil, mostly since Abengoa case, I believe. Our Superior Court of Justice set a standard of what would be needed for an arbitrator to disclose while he's appointed as an arbitrator. So here in Brazil, the treatment of those topics is very different, for example, as it is United States and in other jurisdictions. Since that, in this particular case, the Bengoa case, the arbitral award was confirmed in the United States, and here in Brazil, it was set aside. So, Neeti, how do you see the recent developments in India about conflict of interest, the usage and of the IBA guidelines on those topics, and how do you see that India institutions are facing those issues?
We've had some very interesting developments actually in the last, I would say, a couple of years, or more than a couple of years. So India adopted the 1996 ancestral model law that we had, and we had an Arbitration Act which came in the 96, but we never changed the law thereon till about 2015. Of course, there were judgments of the highest court in India, which is the Supreme Court, not all arbitration friendly. There were issues, especially with the government contract, where government had the option to unilaterally appoint arbitrators as well. Then in 2015, we amended the act, and we came up, what India did was that we adopted the IBA guidelines as a part of our legislation itself. So what you have is the red list and the orange list that came in verbatim as a Schedule 5 and Schedule 7 of the Indian Arbitration Act. How that helped really was that, like I said, we have now a larger pool of arbitrators. You are required under the legislation itself to make disclosures, and you have very helping guidelines to say that what all needs to be disclosed. Also, what we've seen is that the courts have now taken conflict of interest as very serious issue. In the government contracts now, you cannot have a unilateral appointment by just the government. Now, why would I talk about government contracts really? Because again, if you look at the dispute resolution in India, our domestic matters, I would say almost about 60% of our matters, a government or a government entity is a party to it. So you don't want a situation where you just, sign on a dotted line. You don't have much power to negotiate with the government contracts. And then you reach a situation of arbitration and you see that you don't have a right to appoint.
Sorry.
Professor Paulo, he muted. Sorry, Neeti.
No worries at all. So, you didn't want a situation where you don't have a right to appoint. So a Supreme Court has taken some very interesting decisions in the last couple of years and said that even if a contract provides for unilateral appointment, that contract cannot be acted upon in the sense that arbitration agreements survive, but the government cannot just have its unilateral appointment. Both the parties either agree to a sole arbitrator, or if they cannot agree to it, then it's the court which appoints the arbitrator. What we are also seeing is that now the courts are happy to send matters to institutions like MCIA for appointment and to take the disclosures and to make sure that the arbitration gets over in the next 12 months to an 18-month time. So I would say that if you are an arbitration practitioner in India, life is a very different sort since 2015. We are seeing much more international best practices being incorporated. We are seeing that the conflicts being taken much more seriously, an arbitration bar being developed, a larger pool of arbitrators being there. And I was listening to it that you spoke about the CIARB. In fact, CIARB India is a very strong branch as well now, which conducts arbitrator training programs. And we're seeing a very different culture.
Oh. I know it's working. Well, thank you, Neeti. It's very interesting. We have in India a country which internalized the ancestral model law. That is a participant also of the New York Convention, and now has adopted the IBA guidelines as law. So this is very interesting because here in Brazil, when we talk about those guidelines and when we try to use them in court, there is always a discussion. Well, shall I refer to that or not? It is not law. We must use it only as an inspiration or something like this. So I will just invert now. Claudio, what do you think about those issues and the conflict of interest in Brazil, and also taking in consideration what Neeti just said?
I was really happy to hear what Neeti just mentioned, because you solve, or at least you're halfway gone in solving what's Brazil's biggest issue. I mean, when we talk about hot topics, this is the hottest topic in Brazil, even though the actual numbers do not show that we have a problem. I mean, we have a poll. It's a result of a research undertaken by the Brazilian Jurimetric Association, in which we have actual numbers. It's not out yet, but the real number is less than 1.5 of judgment set aside in terms of impartiality or independence of arbitrators, which is a very, very low number. But maybe what India did, and I have my reservations on the IBA. I like it, but I do have my reservations. And maybe what India did was, it's way better to have a not so good solution than having no solution at all. And here in Brazil, I mean, it's quite the contrary. Right now, we have a claim in the Supreme Court in which one of the requests is to ban the use of the IBA at the Supreme Court. And we have at the same time a guideline issued by the Brazilian Committee of Arbitration. I'm not sure if it's arbitration or arbitrators, because as far as I understand, it's the view of arbitrators, which is also a defendable view. And then we have the view of the judiciary, which, as far as I understand, is possibly the worst, because it's not the view of the users of arbitration. And what Brazilian Arbitration Act makes express mention is at the eyes of the parties. But there is no more partial party than the party. I mean, by nature, they're partial. So we're in a loophole of an absolute absence of a criteria. And the core of the matter is, what's the criteria that Brazil will adopt? So in the midst of the perfect tempest, it's a hurricane, and as we have India, a typhoon, and it's unbelievable what's going on here. But it's not all bad, because at some point we will have a criteria which might not be the best, or probably not the worst, I believe, I hope, but we will have a solution.
Well, what seems clear to me is that India has been investing in arbitration and trying to promote arbitration, and also get some indications and cases from other countries, trying to attract investors with this strategy. Once India adopted the UNCITRAL model law, adopted is part of the New York Convention, and now also adopted the IBA guidelines as a law of the country to resolve conflicts of interest and all those things. It seems to me that India is trying to attract the attention and investors of other countries, because and we are seeing that this strategy is giving some good results. It's presenting some good results, as we are seeing India with a considerable boom of arbitrations. So, Lilian, Oh, yes. Professor Casella is already here. So, Professor, please, Professor Casella is the chair professor of international law of the National Public Law in the São Paulo University. And he's also the coordinator and the leader of the study groups on BRICS countries, which I am part of. So he's been studying India and law in India and India tradition for a long period, and is one of the greatest authorities we have here in Brazil when it comes to collaborations among BRICS countries. So, Professor Casella, if you want to make your remarks on possible collaborations between Brazil and India in arbitration and any other topics that you are involved with, please, the floor is yours.
Good morning, good afternoon, ladies and gentlemen. It is a pleasure to be in this short participation in the event organized by the FIESP, the Mumbai Center for International Arbitration, and José Nantala's law firm as well. It is an opportunity to meet some colleagues, to see again some well-known faces, like Professor Finkelstein, hello, and also to insist on a topic that I think we have already learned along the years since the BRICS started, that one of the most important aspects is for us to get acquainted with each other, to know how things work in one country and in comparison with another. And now we'll have this enhanced effort to be carried on as starting January 1st, 2024, BRICS, in addition to the original 4+1 with South Africa since 1911, we'll have 6 more countries, so that we'll have plenty of efforts to study and get acquainted with the new tendencies. It is something which I remember. Now José Nantala is completing his doctoral thesis, but when he was working in the master dissertation, he decided to make an examination of international commercial arbitration in the 5 BRICS countries. And I was a witness of how much work and dedication is required from José Nantala. And one comment you made at the time is, happily you could speak Portuguese, because the Brazilian sources were the most, the ones that lacked most the user-friendly requirements of it. You could get access to documentation and legislation. Obviously, in case of India and South Africa, English is an official language, but also for Russia and China, this was more often the case than for Brazil. So this only reinforces the comment I was just making, that one of the most important things is for us to get acquainted. And it is important that law operators, lawyers, legal scholars are acquainted, so that when you have to present to a client the possibility, should we start an arbitration procedure in Mumbai or in another center in India, it is important that we know what we are talking about, because you have to be convinced yourself and then to present the possibilities and risks to your clients as well. So this is an effort that deserves to be pursued and deepened, and we will have plenty of room for new events in the coming years, with 6 more countries added to the BRICS. So this is what I could do today in the middle of my morning at the university, in the pause between 2 courses, to say hello, to wish you a good continuation of the work, and I hope to be part of the following initiatives with the 6 new member countries of the BRICS. I thank you for your attention, and I wish you a good continuation of the work of this seminar. Bye-bye.
Thank you very much, Professor. It's a great pleasure to have you here with us. We know the effort that you are making. You are in your you are taking advantage of this. You are really in the middle of two courses. So it's a very little time, and we know that you could use this for any other things, and you are here with us. So thank you a lot for that. And Professor Paulo is also one of the arbitrators of the arbitrators list here of the CMA CIESP FIESP. So he is in his house as well. So Lilian, what is your view?
So the IBA guideline, it's not mandatory for us, but it's an important guideline for the disclosure of the arbitrators. And in practice, we see when we have challenges for the tribunal, the IBA guidelines, it's one of the arguments that the members of the committee will use to solve the situation. We have to our ethic rules and the law, our arbitration law says some criteria that we need to observe too. But in fact, we are living a movement here in Brazil that our arbitration law it's under attack. I think the arbitration is attacked, and we need to talk about it because some interest that we don't know, private interest, is I am careful, sorry, because it's a sensitive theme. But yesterday I was traveling and I was with a congressman on my side. And we are talking about a law project that wants to change our law. And we have a very good law, and it's based on Citral 2. So we need to talk about it. We have some questions that we could improve about the conflict of interest, but I think that the system that we use, the institutions, the most institutions use, works fine. It's okay. We don't need the judiciary or another law to regulate the conflict of interest here. So the market is okay to promote an auto-regulation. It's the point. And our law, it's 7 years old, I think. So we can change the law only because a company had a problem in a procedure, okay? It not makes sense. So it's about it.
Yes, Lilian took the sensitive point in a very appropriate way. So, and really, as you are having the opportunity to discuss with us, Neeti, you are seeing how this particular topic is the greatest worry that we have here in Brazil regarding arbitration practice, because it's been used as an argument for the annulment for the set side of a few arbitration awards. They are few, they are not many, but they there is a phrase that I don't know, I don't remember where I read it, but is an airplane is only news when it crashes. So this is quite the case here. We have few arbitration awards that have been set aside by the judiciary, but they were very mediatic. So the impression that we have falling have, and what Lilian said is really the truth. We need very few changes. We need to clarify maybe, but we don't need a deep change. Actors, to use an expression of international relations, are willing to. So, just taking advantage of this particular topic, it would be nice if we could discuss just a little bit about the collaborations and the relationship between arbitration institutions and the courts, the state courts in Brazil and India, because we know that arbitration needs court here in Brazil, in our law, to help with document production and many other interests of the parties when we need enforcement power that the arbitrators here in Brazil do not have. What is the situation, or what is happening in India regarding this particular point, Neeti? How do you see the relationship between arbitration institutions and the courts?
So to answer this question, I mean, I always say it's very difficult when you talk about India as a whole. We're a large country, of course, and which you can appreciate, of course, in that sense as well of yourself. What happens really in one state may not actually happen in another state as well. So we have certain jurisdictions like Mumbai, Delhi, maybe Bangalore, which is Karnataka, where the judiciary is much more pro-arbitration. And if you look at the jurisprudence in the last 10 years, you would see that the courts have been very less interfering, especially if there are foreign awards involved. But of course, this may not be the story if you were to go to jurisdictions within India where you do not see much commercial work happening. And that is when sometimes you get the matter stuck in the court. You may not get a favorable, reply from the court that you're looking for. And that's why it is very difficult to just generalize India as a whole and say that courts have had one sort of approach towards arbitration. Of course, our Supreme Court, which is the highest court, I can say has been very pro-arbitration, not only in terms of not interfering with the awards to the extent possible, but even promoting institutional arbitration. So as I was saying in the beginning of it as well, that in India, really, we have the ad hoc arbitration culture. I think not only the amendments in the legislation 2015, but also how our courts have been promoting institutional arbitration is quite a happy state of affairs to be in. In fact, MCI was, got the advantage of that approach, and our first matter in itself was as an ad hoc matter which had gone to the Supreme Court of India. It was an Indian party and an African party who had entered into a contract. They were not able to appoint an arbitrator, and that's why the seat was India. So they went to the Supreme Court, and Supreme Court said that rather than we appointing an arbitrator, we would designate an institution to appoint an arbitrator and to move ahead with it. So those are the kind of developments that you're seeing in promotion of arbitral institutions in India. In terms of, interfering with the awards, again, the approach that we've seen of the courts in India is that if it's an arbitral institution award, the courts are very reluctant to interfere in any sense of it. Until and unless, of course, on the face of it, they feel that any of the grounds which are there in the ancestral model law are there, and they see a reason that this should be set aside, the courts will be very, very wary of it. What we have also done is that, Nantala, that we have awards which are challenged in India, purely domestic awards. The grounds are a bit more, I would say, expansive there. But when it's a foreign award, which is, coming in for an enforcement in India, the courts again have a very narrow, restrictive approach to interfere even under the public policy of India. And I can tell you, there was a statistics done in the last 15 years. Not even a single foreign award has been refused enforcement in India. It takes its own fair bit of time to reach there. Our courts are clogged with work. We are very infamous for delays in all of it. But we have not had a situation where ultimately the award has not been enforced in India. So our courts per se are now very, very pro-arbitration, for sure. At least our Supreme Court is very pro-arbitration.
Very interesting. And this also shows how the development of international arbitration in India is going on. If you have no problems enforcing international awards, this is very good news. I remember when I was studying the BRICS countries and international commercial arbitration in BRICS countries in my master's dissertation, and I remember the Bhatia case that was very famous in the Supreme Court of India by that time, in which there was an issue regarding public policy and the adoption of a public policy standard, and of the using more applying for an international arbitration the same levels as the domestic ones, but while I was still doing my research, I remember that Bhatia case was forgotten by Supreme Court most recently, and then we can see how it's developing, and that's very good news. So, Lilian, so just Neeti.
It's very interesting how you bring in the case of Bhatia, which I wear another hat if I teach at a couple of universities in India, and we always have a discussion around it, which anybody who's interested in the arbitration jurisprudence would love to look at the judgment, because that was a case where there was a lacuna in our Arbitration Act itself, and how the courts tried to, read into our act so that a party does not go without a relief, which of course in future judgments got overstretched. But thankfully now we are back to it. We have amendments to the act, and this was more an interim relief where the court said that just because you have a foreign seat doesn't mean that you cannot apply for an interim measure in India. But very interesting judgment to actually read. But now, Nantala, I can tell you with the amendment, even if you have a foreign seat, interim measure can be applied in India, and the courts have the power to grant that. So yes, over to you.
Very, very nice. Very nice. Thank you so much. Lilian, what is your view?
In Brazil is so big too, but in general, our superior courts and the Supreme Court, it's friendly to arbitration. It's necessary to ratify the foreign centers to execute here in Brazil, but it's work fine, I think. Sometimes countryside have some difficulties to should the judges understand better our arbitration system. But in general, I think the arbitration system and the courts are very collaborative. I don't know if Professor Claudio has a different vision.
Sorry, no, I tend to agree. Except for those highlight cases, the relationship between the judiciary, not only on the high court, even on lower level, it's been working, and it's been working fine. Just like you said, I mean, the system is working. It is working, and for 99.9% of the cases, we don't need changes. Of course, I mean, everything can adapt and evolve, everything, but not the way it's being proposed in Brazil. I do agree the relationship it's going fine. We have a number of members of the judiciary that they come here at this institution, they come at the universities, they debate. They're even though they don't accept some ideas, they're open to debate, and this is very good. It's very good. It's working.
It's very nice mentioning CIESP also here. We have judges that are members of the CIESP, for example, and other institutions here in Brazil. So going on as well and moving forward in a good way. Regardless, those very specific cases jeopardize the whole system, which works really fine. Just one more, just a closing topic here. We are really finishing our time here. So just a broader view on what are nowadays the biggest challenges that we have in arbitration in India and in Brazil. Neeti, what do you see and what are you experiencing as a great challenge? And when I mention challenge, it doesn't need to be a challenge that is something bad that is happening, but a challenge that's something that you feel that it needs, that practitioners are seen as opportunities to move on and build an even better place to work and to develop arbitration. What is your view on that?
Nantala, I would say, okay, let me take challenge as a negative thing first, and then as a positive thing as to where we build it up from. I think as a negative, I think is that India has now become so pro-arbitration that we're seeing so many changes happening. We didn't amend our act from 96 to 2015. And then we amended again in 2019, again in 2020. And currently, as we are speaking, we have a committee which has been set up by the government to again look at the Arbitration Act. And we may have some recommendations coming out of it again. I think an over legislation and over enthusiastic legislation is sometimes a problem as well. So that's a negative challenge that I see really in that sense, because there needs to be a sense of continuity when you change a legislation to see how it develops and then to make further changes. But I think what's the interesting thing with India is that as one of the fastest growing economy in the world, also we're seeing that our Prime Minister has said that by 2025, it will be a 5 trillion economy. And this is not going to happen from jurisdictions like Delhi or Mumbai. We are seeing much more trade, business, development, infrastructure development happening in smaller cities, what we call as tier 2, tier 3 cities, and sometimes tier 4 cities as well. And wherever there is trade, there is dispute, which we dispute lawyers unfortunately live on, like it or not like it. And that is where we are seeing quite a change, in India. It's a very exciting time to be collaborating, to be doing business in India, but at the same time having certainty that if your investments were to go down the path that you're not anticipated, now you don't have to see yourself in courts. You have very robust arbitration as a dispute resolution mechanism, which is supported not only by legislation, but by the government, by the practitioners, and having presence of institutions like MCIA, not because I work with them, but I think generally otherwise, has really changed the way that the disputes are being resolved in India. So I think the next 5 years and the next 7 years are going to be very, very interesting. And especially before I conclude on this, I think I was doing my research in Brazil and India. We've always had very good relations between the two countries. We are also one of the top 5 largest trading companies. And whenever we are doing our international roadshows, one thing we always say is that Germany, of course, is one of our larger trading partners as well. And I was in Germany a couple of weeks back, and I said that it's rather unfortunate that when an India or a Brazilian company contract, they have to think of doing their arbitration in another third jurisdiction. When you have institutions in Brazil, you have institutions in India, you have best of the legal minds in either of the country, there is no reason that parties should be feeling more comfortable to go, to a Singapore, Paris, London, Hong Kong, and any other place. They should very well be comfortable to resolve their disputes within India or within Brazil, or a mix and match of the two. And I think that's really the message that we want to send across, is to say that we love to collaborate with other institutions. We would want to provide a more certainty for the businesses doing business in India to say that they can resolve their disputes if the business was to go sour. And that would be my message, really.
Wonderful. Lilian.
I totally agree with Neeti. Sorry, my voice. But Brazil, it's a country, one of the countries that have more cases than ICC. So why we don't receive, and why we couldn't be the seat of these international proceedings? So it's our challenge. I think we need to work to demonstrate that we are secure, we are arbitration friendly, that our courts are arbitration friendly. So why not to host these proceedings here?
Host the proceedings, bring money, bring investment. This is all very important. Arbitration is not only a proceeding, is not only about a measure to resolve disputes, is also business. So promoting arbitration is also promoting business. You said it very correctly, Lilian. Claudio, what do you have in mind?
Well, my take is about the same. Mostly with domestic cases or international cases where enforcement is sought in Brazil, because we have a particularity. I mean, arbitration seated in Brazil are treated as domestic awards. So, whereas the international arbitration awards are treated as international judgments, and I don't have a problem with that, even though it's not the idea of the New York Convention. But for people doing business in Brazil, Brazil has proven to be an excellent seat. Some people, I mean, we just had an article on Valor, praising London as a seat of arbitration, and of course London is an outstanding seat. I mean, this is, we don't want to diminish any other seat, mostly London, but for many, not many, for most cases, it just don't make sense to go to London to arbitrate under Brazilian law, or in any case where enforcement or recognition, it's to be sought in Brazil. It's way faster, it's way cheaper, and probably the outcome would be the same. The quality of the services. It's a pity Neeti is not here to see this arbitration facility. I mean, the hearing rooms and the staff at FIESP, they're outstanding. I mean, maybe we speak with a different accent. That's about it.
Yes, this is very nice that you mentioned. We are here at the hearing center. So this is where everything happens in CIESP. And it's very, very nice to hear you and to talk about those very interesting topics. I am so glad to be part of this conversation, and hopefully we will see FIESP and MCIA working together. Hopefully we can see you collaborating. And please, I'm always ready to help if you need, because I see this as the future. I really see jurisdictions as Brazil and India as a bright future for arbitration. I just want to read a statement that Professor Peter Sester is from Germany, but he's working here in Brazil for a long time. He got married to a Brazilian, and now he's working here. He's also speaking Portuguese better than me. Let me take here what he just said about India, with what I think it's very interesting. Well, he said in Portuguese, but I'll translate it. Very good. As always, Cláudio is one decade ahead of everybody. While all arbitration markets are shrinking, India gives hope for growth. So this is very interesting, and I really believe that as a key to the future, and working on collaborations like this is always important. So, Lilian, Neeti, do you want to make your closing remarks?
Yes, definitely. I mean, I think, Nantala, this was, I must congratulate you for having thought of this. To be very honest, it should have been a very natural progression for India to think of its relationship with Brazil to collaborate more. But I'm very sure this is just the beginning of what we will see, a much larger cooperation, a much larger development of the arbitration culture between the two countries. And like I said, I will try my best that I do this next year in person. I must admit, I haven't been to Brazil yet. Probably would be a good opportunity to talk about arbitration, to collaborate with Lilian, with the institution, with you, Nantala, and do some of my holiday bit as well. So to the arbitration culture between India and Brazil, going strength to strength.
Lilian, please.
I want only to thank Nantala. It was a great opportunity to discuss and understand better the international system. And Neeti, I'm here for you too. So I want to promote more initiatives together, please. And to thank Professor Cláudio. Professor Cláudio, it's my professor too. So I really want to thank your presence here, and all people that are here too. Thank you very much for participating.
Professor Cláudio, the final words.
No, the closing remarks. No, final words is please.
Yes.
Not as of yet. No, it's been a pleasure to be here with Lilian. I mean, just shining as she did, even way before she was my student. and Nantala and Peter mentioned my name. I'm ahead. No, I'm actually coasting on Nantala's initiative. I have to once again congratulate you all for putting up this event, and it's really a pleasure to get to know Neeti, even though from a distance. We briefly talked over WhatsApp yesterday. It's really a pleasure to share those moments with you guys and also the staff of FIESP CIESP. Those are excellent people and outstanding professionals. Thank you very much.
Well, so we are at the end of our events. Thank you so much, everybody. Thanks a lot for the audience that we are that is in YouTube and the FIESP channel. So let's hope we do this again next year. Neeti, you come to visit us, and I'm surely coming back to India as well. I love your country. I've been there only to Rajasthan, New Delhi, and Mumbai, but I want to know much more. And let's do things in India as well. So thank you, everybody, and stay tuned for more initiatives like this, as both institutions are really committing themselves to it in a live event. So we better move forward. Thank you so much. Bye-bye.
Bye-bye.